Vincent Ekow Assafuah has filed an application at the Supreme Court seeking an order to halt the suspension of the Chief Justice Getu Tukano from office pending the hearing and final determination of the case. This comes after President John Mahama on Tuesday, April 22, suspended the Chief Justice and constituted a 5-member committee to investigate 3 petitions seeking her removal over allegations of misconduct. The application filed today by the former Attorney General Godfrey Wadem on behalf of the Otafo Member of Parliament is expected to be heard in court Tuesday, May 6, 2025. My colleague Denis Pwaberi Wadem Esquire is joining me in the studio with the details of this said application. Let's first of all, Denis, understand this. The suspension has already taken place. The President has suspended the Chief Justice.
That is so.
What is this particular application by Vincent Assafuah seeking to do, essentially?
In his own words, suspend the suspension.
What does that mean?
Well, so he's basically saying that the Chief Justice having been suspended, he's now going to the Supreme Court, asking the Supreme Court for an order to put that suspension on hold. That's me using different words to describe suspension. So that's the essence of this particular suit. And it is one which has been mounted on a substantive matter, which is still pending before the court, to the effect that they do not even think this whole proceeding was started off on the right foot, for which reason they want the Supreme Court to declare it as unconstitutional. Their main contention has basically been the fact that the President ought to have, first of all, forwarded the petitions received to the Chief Justice, notifying her of those petitions and asking for her response. Then before the processes of consultation could begin. They are of the view that for the fact that an announcement was made that there was an ongoing consultation, before, along the line, the Chief Justice was given the opportunity to respond or even notified of the existence of the petitions, was in clear violation of the provisions of Article 146 of the 1992 Constitution. They still stand by that. But now, looking at the fact that some events have evolved past their initial injunction application, which was to the effect that the consultation process should be halted, that we have moved past that already, because we do know, per the statement from the presidency on the 22nd of April, that's now a prima facie case has been established, which means that the consultation between the President and the Council of States has come to an end, and that was how they concluded. They put together a committee, and then subsequently the Chief Justice has been suspended. So what that effectively means is that the relief that was sought in that particular injunction application, which of course has been adjourned twice, it will be heard on this same day that this new one will be heard, was to determine the matter of that nature. But now what we are having before us is one that says that now let's get an order from the courts that will first of all suspend all the processes that are in motion now, and then again one which will suspend the suspension of the Chief Justice. In other words, let's get the Chief Justice back to office, suspend the whole proceedings until a determination is made whether or not it is lawful for the President to have first of all decided to engage in a consultation process with the Council of State before notifying the Chief Justice of the pendency of petitions and even asking for her responses. So that's basically the crux of it. But Alfred, what is important in this particular application now is the fact that in what the additional facts that they've added to this is to the effect that they have now begun to show by way of information and trying to make an argument that this whole thing that you are seeing is premeditated. So you would find that in their affidavit in support, they make references to some commentary that was made by the President, who then was the opposition leader, to the effect that at the time was expressing some misgivings about the conduct of the judiciary.
Right.
And in what they see was some comments he suggested that he was going to have a new Chief Justice who was going to be non-partisan. They also make reference to some interviews that had been granted to the media by some key government officials or appointees. They make reference to a statement that was made by Dr. Rashid Tanko Computer, who is the Deputy Director of IT and Elections for the NDC, to the effect that they are, upon the suspension of the Chief Justice, that the NDC is pleased So they point to that particular statement. They also point to one that was made by Mustapha Bandi, Director of Operations at the Presidency. He also happens to be Deputy General Secretary of the NDC, to the effect that the Chief Justice was going to be removed. So they say when you put all of those things together, it meant that this whole process was premeditated. And essentially, considering that this is an injunction application, they make the point strongly that if the processes are not stopped or suspended, and then at the end of this whole committee hearing, the Chief Justice, for instance, is cleared, the harm that will be caused or the damage that will be caused will be so huge that it cannot be repaired. And typically, when you are persuading the court to grant you an injunction application, you need to show that the harm that will be caused at the end of the action will be so huge that it cannot be repaired or cannot be made up for with damages. So that's the argument they are making. And to that extent, they want the courts to put the process on hold by way of granting them this injunction application, and then wait till the final determination of the substantive matter, Alfred. So,
and you made reference to the fact that the president only carried out the constitutional mandate of suspending the Chief Justice, essentially.
Yes, but their contention is that the president did not do so following what the Constitution actually stipulates. So that is where they are now invoking the jurisdiction of the Supreme Court to, by way of answering that question, actually interpret. For instance, they're making the point that, first off, when the president receives the petitions, he has to notify the Chief Justice first, get her responses before the consultation together with the Council of State can begin. Their contention is that in this instant application, in this instant case, when the president received the petitions, in fact, they make the claim, the case that the petitions were actually delayed for about 3 weeks or so. Then a consultation process started before they got the Chief Justice's response. So it's a question of whether the first step should be the consultation before getting the input of the Chief Justice or the affected person, or that the affected person's response should be elicited first before. That is a substantive question that the Supreme Court will answer if it is minded to go into the substantive case. But what they are saying is that even before that question is answered, it's important for all that is happening now to be put on hold. If not, if at the end of the day, the Supreme Court makes the determination that no, the president ought to have first of all notified the Chief Justice, got her response before the consultation process, and then for some reason she's already been maybe adverse findings have been made against her and she's been removed. They are saying that that particular harm that will be caused cannot be repaired, for which reason they think they are entitled to the grant of this injunction application, Alfred.
What other reliefs are they seeking? What other reliefs?
Yeah, so substantively, I mean, all those other ones point out to the same destination. That first of all, let's stop the process that is ongoing right now. Also, let's suspend or give an order that suspends the suspension of the Chief Justice. In other words, put on hold the suspension, let the Chief Justice come back to work. I mean, it comes in various forms, but bottom line is those are the two key things that they are looking out for in this particular application. So on the 6th of May, this will be one of 3 applications by way of injunctions that will be considered as to whether they will be minded to withdraw the earlier ones, which I have explained to you that events have actually overtaken some of them, or they also want to go and add this one to it. It's at their discretion, and also for the courts to make that determination. Well,
this same question was put to the Deputy Attorney General, Justice Adam Shemsai, Dr. Justice Adam Shemsai, about these pending applications against the process and what will become of it on the same day, May 6th, is it not?
Yes.
Same day. And this was his response.
Yeah, so thank you very much for the question. As my boss indicated last week, when it comes to constitutional function, I think the position of the law has been that no one can prevent a person from performing a constitutionally mandated function. The only circumstance at which the person may be prevented or may be restrained is when a court makes an order for the person to be restrained. As we stand today, there is no such court order which restrains the president from, or the Council of State from continuing with the process which the Constitution mandates them to perform. So I would reiterate the point that my boss made last week, that there's no restraining order for on any of the aspects that the president and the Council of State.
I mean, there are those who make the point that by virtue of this action, you have basically rendered the two cases that are seeking to injunct the process, you have rendered those cases moot. And they make reference to other decisions in the past of the court that suggest that you ought to simply hold on and not take any steps that potentially affects the possible outcome that the individual is seeking from the court.
No, so there must be, I think people, we need to look at two things. There's an application for an injunction, and also there is the substantive case, okay, to the Council of State. I've gone to the Council of State before a reference is made to the Chief Justice involved. Even the previous, petition which the former Attorney General, that Wadem government superintended over, the record shows that it was forwarded to the Council of State before the Chief Justice was given a copy. So even though it's a strange proposition, we believe that a clarity from the court could be useful.
That's the Deputy Attorney General, Dr. Justice Hessel-Malm there. Hessel-Malm is private legal practitioner. He's been following this case every step of the way and how it's evolved to this moment. He's joining us on the telephone right now. So, Counsel, good evening. Thank you for joining us.
Hello, good evening, and thanks for having me.
First of all, the latest to this is that, apart from the number of statements we've got from the Ghana Bar Association who say that, well, the process must be allowed to play out as enshrined in law and not politicized, and the Federation of International Women Lawyers also coming in that respect, essentially. The Member of Parliament for Otafoh, again, Vincent Assafuah, has filed a suit at the Supreme Court essentially challenging the president's suspension of the Chief Justice. He is seeking the Apex Court to reverse the said suspension on the basis that the president had violated due process because of a pending court application. You just heard the Deputy Attorney General make the point that in their view, it cannot be the case that the president violated due process because of this pending application, because the president only carried out a constitutional duty. How does all of this strike you?
Yes, thank you for having me, and good evening to your listeners. You see, the important thing to note is that by the Mahama Bugri case that was decided by Akabuafo J. as he then was now at the Court of Appeal, it dealt with pending injunctive applications before the court, and in his decision, he directly dealt with such matters that where, aside the fact that other authorities had established that applications pending, which had been determined for court orders to come by, the remaining gray area was where he touched on, where pending applications are before the court and await determination. In situations as that, where the other party is acquiesced with it or is apprised with it by way of knowledge, then that particular person or party need to restrain themselves pending the determination of the matter. But he further went on to give a caution that the court should hasten slowly when it comes to constitutional duties. You see, so the legal principle is not an established one. So on Saturday, as you hosted me, the point that I was putting or establishing was that in the sense of wisdom and respectfully, the president could have hastened slowly in allowing the application to be determined. Thereafter, whatever steps that the president ought to put out could have been put out. Again, it must be put on record that the president has not done anything unconstitutional as far as Article 146 is concerned. He has carried out 146, he has carried out 14610, which deals with the suspension. So there's nothing unconstitutional. Now, this application coming in to challenge the constitution, the suspension. Well, an injunction is a timeless one. It's very, very important in bringing the application. The time the application is brought can can cause the application to win or for it to be dead on arrival. As we look at the timeline, the suspension has already taken effect. So, and mind you, injunction applications, they are discretionary in nature, and it's an equitable remedy, and where the court will defer to CIS 47 under Order 25 to deal with it. And among the basic elements to establish is the irreparable damage, the balance of convenience, the legal rights, and all of that. So, in the circumstances where a timeless application is needed, the horse has already bolted. The suspension has taken effect. There is an acting Chief Justice. The question remains whether or not it is moot. It is for the court to decide. We are only doing education. We leave that to the eminent justices to do that. But by way of education, where an application is moot, that which you are seeking to cure, because it is an equitable remedy, has already bolted. It's already in motion. What is there to hold? You get it? It's just like someone is building your property and you are seeking to injunct the person. Yet the person has a completed house. So the person files an opposition to say, my lord, I'm already done building the property. So the injunction application is not needed. All that needs to be done is we have to go to look at the matter itself. But to the injunction application, once it's moot, it's dead on arrival, and the court might tell you that, do you still want to move your application? Then you get the demeanor of the court. But, I mean, with this one, we look at what the judges would say, but given right from the go, it is obvious that you don't need to have legal lenses to know this, that the timeless nature of it is suspect, and that remains one of the weaknesses of it. However, the constitutionality of how the president has carried himself, he has moved within the confines of the law. It is only that certain quarters have prayed that the president, even though had the powers to take the necessary steps that he has taken, should have measured himself a bit to allow the determination of that particular application, so that it would, whatever step that he wants to take, he could carry it anyway, because that is mandated under Article 14610. You get it? So the question I'm going to ask now, it's a very important explanation you give, and also the references you make to the timing of this particular application being essential in bringing applications, because this action that this application is seeking to halt, as you indicated, has already taken place. The Chief Justice has been suspended. So what will be in such cases, what position does the court take, especially? I will not want to seek to be the legal advisor to the parties, but I would have loved to see how, in the light of the injunction application, I don't want to mention the name of the process, the processes they could have brought to challenge the president going forward with the constitution of the committee, and in the light of the injunction, for the Supreme Court to have the opportunity to clearly deal with when there are pending proceedings before the court and involving constitutional matters, or when constitutional matters run parallel with it, what happens? Because now the gray area of it is that in such situations, the court should hasten slowly so that it will not act as a fetter and a clog to a constitutional duty that can affect the constitutional decisions of the country. So that process, which I don't want to mention for whatever it is worth, would have granted the Supreme Court the opportunity to clearly deal with that aspect of the law so that going forward it becomes very meaningful to refer to. But with the current application that they have filed, I mean, repetition should save ourselves, but what I've said about it is that it is late in time. What they are seeking to have it cured is already existing. So what is there to be cured?
Counsel, appreciate your time on this matter. Thank you so much for joining us.
Thank you.
Hessel-Malm is private legal practitioner on this particular development. Meanwhile, the Ghana Bar Association has condemned what it calls the over-politicization of the process to remove the Chief Justice Gertrude Isaba Saki Tukono. The comment follows a statement issued earlier today by the Ghana Bar Association in which it demanded fairness and a strict adherence to the rule of law in this entire process. Public Relations Officer of the Bar Association, Xavier Kuji, spoke to Precedent earlier today.
The whole issue has taken a political dimension. We, as a country, or many people who are running commentary on this, have forgotten the legal aspect of it, to the extent that the two major political parties make it seem as if it's business as usual as far as politics is concerned. So there was a need for us to step in at this time to say that it's a whole process. So let us all be restrained, be patient enough for the process to get concluded. The outcome of the determination by the committee set up by the President will determine where we should go. Those who are aggrieved, of course, the courts are there because the decision of the committee, of course, is subject to the jurisdiction of the court. It's not for me to pass judgment at this time because it's a process. Unless the process gets concluded, I don't think that it is proper and appropriate for anybody to condemn any process, because don't forget, at the end of the day, the courts are there. They can determine the procedural impropriety or otherwise of the whole process. So I think that it will be premature for anybody at this stage to be condemning the process at any stage. Not necessarily, but I don't think that it is out of place to remind the actors in the process of the fact that they should stick to procedure and processes and the rule of law. I don't think that they are humans though. They may get influenced. They may. I'm not saying that they would. So there is nothing wrong reminding them of their duty to stick to these processes and the rule of law.
Xavier Kuji there. He is the Public Relations Officer of the Ghana Bar Association. Away from the matters of